favour of national economic interest. That is the Supreme Court making an observation as it delivered a judgment in a case between two sugar companies. Mincing no words, the Apex Court bench of Justice A.K. Sekhri and Abhay Manohar Sapre had a clear message to the judiciary at large. I quote, "Evaluate economic interest of a case before delivering the verdict," unquote. Ashmit, Kumar and Utkarsh Anand are here now with more on what this landmark judgment could mean for India Inc. and the economy. Guys, over to you.
Right, so the Apex Court going in for some introspection, going in for some course correction. The Apex Court, by way of this judgment, making it very clear that in today's day and age, it's critical that economic considerations, economic impact of its decisions becomes a key benchmark, becomes a key factor at the time of the judiciary passing those big decisions. For more on this judgment, I'm joined by the legal editor of CNN News 18, Utkarsh Anand. Utkarsh, the first question at this point, the Supreme Court is speaking of the economic analysis of law. What does that effectively mean, and in which direction is the court pointing?
See, what the top court points at is the fact that there is an interplay, essential interface between law and economics. You have law on one hand and economics on the other hand. So that interface must be kept in mind when the courts are interpreting law and deciding the cases where major stakes are involved. Now, as I was telling you earlier, this also means that when India has been on a growth path, there have been policies by the government. So courts must supplant in implementation of those policies, and while they decide it, they must keep into account the fact that India is India is a growing economy. It has been making policies in that direction. Now, apart from that, what must also be taken into account is another aspect of it, that it is the bounden duty of the courts to have economic analysis, economic impacts of its decisions.
Right, it's interesting that you point out the economic impact, because one does get a sense that this will have severe ramifications in terms of decision-making by the judiciary, in terms of commercial cases, in terms of policy decisions that are under challenge. And clearly, this becomes apparent from what the court observed as a part of the order, that if there are two views possible, the courts need to lean in favour of the view that subserves the economic interest. So the Apex Court not mincing words. It also goes on to say that the Supreme Court or the judiciary at large must avoid outcomes that can hurt employment, growth of infrastructure, economy, or revenue. So that is the position that the Apex Court has made it clear. And furthermore, it adds that when economic interests are in competition, are competing with the rights of other persons, there is a need to strike a balance. So the Apex Court taking a very aggressive view in terms of pushing this view forward, that perhaps economic consideration is the need of the hour. But going forward, when we look at matters that are pending, the issues that are currently pending, which are the big cases that, according to you, will see an impact of this judgment? You
have this substantial bunch of cases on mining, which affects various states, including Goa, Orissa, and Karnataka. Then you have hydel power projects in Uttarakhand, which have been stuck, and all these cases are in the Supreme Court. Now, the third most important bunch of cases would be the land acquisition matters, which in fact affect all the infra projects. Yeah, the fourth, and which could be in fact the hot cake, is the Aadhaar matter, the right to privacy matter. You have a right, but then the economic interests of the governments. Now again, the WhatsApp privacy policy matter. This is again one more matter which is very crucial as far as this judgment analysis is concerned.
Indeed, and what's interesting is that as a part of this very same judgment, the Apex Court, while introspecting, has said that there have been instances of economic considerations being taken on board, but that has been an ad hoc exercise. And the words that the Apex Court uses is that there is a need now for a profound movement on a sustainable basis towards this strategy of employing economic considerations as factors while decision-making.
All right, Ashmit and Utkarsh, appreciate you joining us now to take us through the details of that judgment. Joining us to discuss the implications of that judgment, the former Additional Solicitor General of India, Bishwajit Bhattacharya, Arvind Dattar, Senior Advocate with the Supreme Court, and Senior Lawyer Rohan Shah. Gentlemen, appreciate you joining us here. Mr. Dattar, if I can start by asking you to interpret for us what you make of the order from the Supreme Court and the implications this will have. When the court says must avoid an outcome that can hurt employment, growth of infra, economy, or revenue, when economic interests compete with the rights of other persons, need to strike a balance. I mean, let's just take a look at the recent orders. For instance, the order banning liquor vends on national highways, which has impacted revenue of state governments, which has impacted businesses, which has impacted entrepreneurs. In the context of what you've heard from the court today, what kind of implications does this judgment have?
Well, this judgment is most welcome. I think for the first time, the Supreme Court has taken note of the Posner School from the University of Chicago, which has emphasized the need to integrate economics and law. It's a very welcome judgment. And as you rightly put it, in terms of the liquor issue or the diesel ban of vehicles and so on, it will be wonderful if the Supreme Court at least makes an economic assessment, an assessment of the economic consequences of its judgment, whether it's mining or liquor or banning vehicles. They must see what will be the impact on employment, on manufacture, on service, and so on, and take an overall consideration and take a view which will be least harmful to these sectors. At the same time, this view has got its own limitations. If there is a particular law, then the court has got very limited maneuverability. I mean, it can't ignore the law and pass its own judgment on what it thinks is the economic interest of the country. It should be emphasized that if there are two views possible, then the view in support of economic interest will be preferred. But this judiciary can't take a view contrary to what the legislature has said.
Yeah.
But I think on the whole, it's a welcome move. It's for the first time in the history of the Supreme Court that we've got a judgment integrating law and economics.
Rohan Shah, would you agree that this is indeed a historic judgment that we've seen coming from the Supreme Court? And what will be the implications now when we talk about pending matters? Utkarsh and Ashmit just took us through a list of them, whether it's the mining cases, the land acquisition cases, the hydropower projects in the state of Uttarakhand, the plea against Aadhaar, whether it should be made mandatory or not. How do you see this judgment weighing on all of those pending cases?
Shireen, I think very, very important judgment. And in a way probably articulates what Supreme Court has been doing from time to time. So whether you look at 2G or whether you look at it, in the context of the mining cases you mentioned, we've had a situation where Supreme Court has been economically aware. But the one thing we have to understand is that if you take all the Supreme Courts in the world, no other Supreme Court deals with as many important economic issues, both in terms of number and in terms of width, as our Supreme Court. And to have a bench of the Supreme Court say that the economic issues must now take center stage is extremely important, because each of these judgments have a very, very wide ramification. They have a ramification on employment, on capital invested, on bank loans. So bringing this to the center of the debate, I think, is extremely important. It isn't that the Supreme Court wasn't aware or so inclined earlier. Even the judgments that they have referred to in this judgment, Ramnik Lal's case or Dunlop, any of these cases, you did have an appreciation of this. But as the Supreme Court has said, those have been episodic, they're sporadic. Now it's sort of going to be central. But let's not overreach in terms of saying, this is going to really be the dictum for every judgment. Issues of fundamental rights, issues of what statute provides for, a balance in terms of equities between state and citizen. All this is not thrown out of the window. All of this continues to remain relevant. But what it means is that we're very firmly focused on understanding, or should at least understand, what are the economic repercussions of any judgment that the Supreme Court takes. And when that comes into their profile of decision making, I think it can only be good, especially for a nation which is poised for the sort of economic growth we are.
Which is the comment that the Supreme Court has made in this particular judgment as well, talking about where India is poised today. But Mr. Bhattacharya, what is the message that the lower courts will take from this particular judgment as well, sir? And I'm sure that this is a judgment that will be welcomed, for instance, by the government at the centre and by states as well.
Shireen, this is a welcome judgment, if I may say so, and it sends a positive signal to the length and breadth of the country across the judiciary, about 18,000 courts, and also of the high courts. Now, but I have one observation. My observation is the biggest economic interest will be served by expediting the direct and indirect tax cases where huge amount of revenue is still blocked. The fiscal situation of the country, there are 21,46,000 crores of expenditure which has been budgeted.
Yeah.
The shortfall is 5,42,000 crores. So therefore, the basic attack should be to expedite and recover the direct and indirect taxes which are locked up in litigation, number one. Number two, at the end of the day, every activity in the country is inextricably intertwined with economics of the country. So therefore, to fast track and to focus on economics is a very, very basic concept of jurisprudence, and I am very delighted that the Supreme Court has articulated it, because at the end of the day, what is law? Law is the result of human wisdom for the benefit of the society and public at large. The law is not an end in itself. Law is a means and a vehicle to an end.
You're right about that, sir. Let me take that point across to Mr. Dattar. Mr. Dattar, I want to get you to comment on the point that was being made here by Mr. Bhattacharya. And just, to take a look at some data, an ASSOCHAM report as of 2015 pegged the value of just 40 big-ticket infra projects stuck in litigation at about over 4 lakh crore rupees. The CBDT today has set up a committee to look at tax areas of the 9 lakh crore rupee tax areas, 6 lakhs stuck in litigation. So a quick comment on the point that was being made by Mr. Bhattacharya, which is also linked to the observations that have come in from the Supreme Court today.
Well, as far as the infrastructure project is concerned, yes, that's a serious issue. But as far as the cases locked up in taxes are concerned, let me tell you that there is a statistic in the National Madras Bar Association case where it was revealed that 77% of the cases filed with the department go against the revenue. So, and secondly, when you talk of 9 lakh crores, I've been hearing this for the last 25 years. Many of these cases, the amount is so staggering only because of the large amount of interest and penalty. And in the vast number of cases, the cases should not have been started in the first place at all. Like in the case of Hassan Ali, you said that the demand of 1 lakh crores, ultimately the tribunal gave a judgment of 3 crores. So this CBDT tax areas is an extremely exploded, very exaggerated figure, and I don't think we should be very much worried about it. Many of the cases are simply totally untenable, and they just keep fighting it up to the Supreme Court. That's point. And secondly, talking of the economic interests of the nation, I think that this judgment could also be used for the benefit of the SSCs. For far too long, we are completely harassed by reopening of assessments and totally untenable and absurd demands by the department. So economic interest is not just government projects, but also to ensure that the law is not implemented arbitrarily, so that people have got some confidence that the law will be implemented fairly and justly. So we can take that judgment in that direction as well. For far too long, there's too much of arbitrariness and some element of tax terrorism, which I hope this judgment can be used to check.
Mr. Shah, would you agree that this judgment will actually, in fact, curb tax terrorism as well and provide some relief to assessees, not just revenue?
See, into my mind, it's a very forward-thinking judgment. It's a Supreme Court judgment. It will have an impact. I don't think it's sort of going to really cure everything which is a problem with the tax system or tax administration system. Those issues will linger. But to my mind, if we are able to take away from this the factor that economically we're talking about a situation where we need to keep interests of everyone who's involved in the economy, which includes an assessee, I think that would be an important way forward. And coming to what was said in terms of this pendency, yes, many of these demands are exaggerated, many of them won't sustain. But I'm just wondering, as we go to a GST, is there an opportunity for us to create some sort of a mechanism where we can fast track the disposal of indirect tax cases? We had a sunset side type arrangement in FEMA. Is it time that we bring in something to expedite closure of indirect tax disputes, bring that chapter to an end so that, we can move into a GST almost as a new chapter? And I think government should consider using whatever mean or mechanism, probably on the back of this judgment, to see how we can create a device, at least on indirect taxes, to expedite a resolution of many pending cases. Because if you see the cases, the stream of cases probably have 80% of them have as common 40 themes. And if you therefore divided this by themes of valuation, classification, exemptions, you possibly could, in a year or so, set up a special court, even at the Supreme Court or in important high courts, to really expedite this so that What is to be collected is collected. What is set aside is off the books and, off our national record, off the company's record.
Yeah.
And we really move into a GST as a tax into a new era.
Okay, Mr. Bhattacharya, a quick comment on the point made by Mr. Rohan Shah in about a minute, sir.
You see, ultimately, the judiciary will have to move faster. I welcome the judgment, but until and unless the judiciary moves faster, the gains of this judgment may not be sort of visible.
Or as impactful.
Or impactful. So judiciary will have to move faster, and for that, infrastructure of the judiciary must be provided.
Which we've discussed and debated ad nauseum. But let me give Mr. Dattar the final say, sir, since Mr. Rohan Shah brought up the issue of the GST. Mr. Dattar, I know that you don't believe that the GST in its current avatar is the best thing to happen to India. So let me end then by asking you about what your concerns and trepidations are with the GST in its current form, sir.
What I personally feel is this judgment, as Rohan Shah put it, since the basic factor is you must ask the question, how do we interpret the law in favor of the economic interests of the nation? So if we keep that mantra in mind, whenever we get a GST dispute, we should try to make sure that the decision is given in such a way that the nation moves forward and it doesn't get stuck in different interpretations, different views taken, which only lead to more and more litigation. Of course, as far as GST is concerned, it has got all the ills of the earlier system. So I really hope that we don't have the same backlog of cases on that, but I'm not very hopeful on that front anyway.
All right, sir. That's a matter for another conversation. Arvind Dattar, Rohan Shah, Bishwajit Bhattacharya, appreciate you joining us here to take us through the implications of what is a very significant judgment from the highest court of the land.